Aparna madam, go ahead.
Yes, sir. Yes, sir. Sharwari ma'am, over to you.
Good morning, everyone. I'm Sharwari Deshpande. Welcome you all to the 60th Foundation Day of Manikchand Pahade Law College. We are pleased to have you all here to celebrate this momentous occasion with us. We honor the legacy of Marathwada Legal and General Education Society, whose vision and dedication laid the foundation for what we proudly stand on today. And also express our profound gratitude for monumental contribution to nation by Lokmanya Tilak and Annabhav Sathe. We pay tribute to these two incredible figures on their Jayanti Day. Today, on the occasion of 68th Foundation Day celebration, we are grateful to have Honorable Professor Bhavani Prasad Panda sir, former Vice Chancellor, Maharashtra National Law University, Mumbai, as a chief guest, and Dr. C.M. Rao sir, Principal of MP Law College, as President of this program. Now, I request Professor S.N. More sir, Vice Principal of our college, for welcome address.
At the outset, I pay homage to Lokshahir Annabhav Sathe and Lokmanya Bal Gangadhar Tilak for their birth anniversaries. Respected guest of the today's 68th foundation of our Manikchand Pahade Law College, Honorable Professor Bhavani Prasad Panda sir, the President of this function, respected Principal Dr. C.M. Rao sir, all the attendees, all the faculty members, students, brother and sister. Very good morning to all. Today, we have a very special occasion for this grand celebration because in the legal history, particularly in the history of legal education of India, the Marathwada Legal and General Education Society, Aurangabad, had played very great significant role because on the first day of August before 68 year in the year 1956, they had established this college in the name of late freedom fighter Manikchandji Pahade. Because before that, we were going to Osmania, that is Hyderabad or Bombay or Nagpur for the taking of legal education. And the people of Marathwada in the need of any educational institution imparting the legal education. Our founding father had established this college and solved this important problem. And after that, the generations of the lawyers had started to born through this institution, and they had contributed in very good manner, not only at the taluka or district or high court, but even into the Supreme Court of India by becoming the lawyers and the judges of respective courts. Today, I'll take this opportunity, all brothers and sisters, to welcome you on behalf of this great college for celebration of this 68th Foundation Day of this institution. I know that many stakeholders, including our student, particularly our honorable guest, who is going to guide us on the historical aspect of legal education. Very relevant topic for our present, what we can say, the event, the celebration, because we had also the great share in the history of legal education of this Marathwada and Maharashtra and India. So I'll stop here because I am also eager to hear honorable guests on this very important topic. Thank you. Over to you, Sarvari Madam.
Thank you very much, sir. Now I request Dr. Aparna Kotapalle Madam, IQAC Coordinator, for the introduction of the event.
Good morning, everyone. Good morning, respected Panda sir, respected Dr. Rao sir, principal of this college, respected More sir, vice principal of this college. I feel honored to speak few words while introducing this event. One thing is to be very, very clear in our mind, dear students, that when any institution, stands very high position, I won't say we have reached to the top, but certainly we are marching toward its 68th celebration, wherein this institution actually is the first and oldest institution in Marathwada region. As More sir has very rightly pointed out that at that particular point of time, there was no legal education facility in this region. But then, whatever institute you see today, maybe infrastructural development, maybe alumni standing positions, maybe the facilities that are being provided to you all, it is not one day activity or one day work for which generations together have worked, they have sacrificed. Those people who were there in the management, who with a vision to provide legal education, they had worked relentlessly, they have sacrificed many things in their life, and hence we are able to see this day. So actually this day is a day on which we have to pay a tribute to those who have sacrificed even their lives, working continuously for the development of this institution. And we have to show a kind of respect for even all those people who were there in the management, especially the important stakeholder, and they have provided us a platform, they have provided us financial help, and they are supporting us in all the ways and means that it is possible. Secondly, maybe generations of teachers have rather taught in this institute, and as like Honorable Justice Gangapurwala sir. So even this is the day to remember their contribution in the development of this educational institute. Teaching, non-teaching staff, and as More sir also has given a reference that students. So it is every stakeholder who has contributed. So paying respect towards today's, on this today's event, to all those who have contributed for the development of this institute. And of course, it is a day to see, rather to look back where we were and where we are. So when we look at, the institution's history, maybe it was very small institute infrastructure wise, but then certainly the developments have occurred. My dear students, when we look at the vision and mission of our institute, we have a mission in our mind to legally empower young generation of a backward region, and everybody in this August gathering will be accepting the fact that yes, to a great extent we have achieved the goal, as well as we are marching with the same mission. Socially, the legal education stands very, very relevant. That is being provided by our institute, because we are not only involved in the theoretical learning process, teaching learning process, but may it be legal aid activity, may it be NSS activity, through which we are trying to reach out poor and needy people. And thus we are, trying to move on the same direction as has been placed in the mission of our college. Then further, we are trying trying to help the rural people, rather rural students who are reaching to us, and we are trying to make them at par as like urban. So the divide, or rather the gap of urban rural, at least in the educational area, those who are taking admission in our college, we are trying hard to empower them. Women, when we talk about women, when we are looking at a mission, empowering women is one of the mission. And looking at the college strength, student strength, teaching faculty 50-50, male and female. Looking at the students category, almost 50-50, more than 750 students are girl students. So to a great extent, we can say, looking at their participation, looking at the achievements, certainly we are trying hard for empowering women educationally. We are striving hard for the quality legal education. To some extent, certainly we have reached. But as we have a vision with us, achieving the excellence in legal education, so this is the day on which we have to see to it that how far we are empowered and how far we have to march ahead. On this occasion, the guidance which would be given by Honorable Panda sir certainly would be helping us, and it would be a guiding lamp for us to walk on a path towards achieving the excellence in the legal education. I thank the organizers for giving me this opportunity, and wish you all the best. We all, hand in hand, will work together for further excellence of legal education, and we would stand very relevant in the rather social space also. Thank you very much. Over to you, Sharvari Madam.
Thank you very much, ma'am. I feel blessed to introduce you all our today's chief guest, Honorable Professor Bhavani Panda sir. He is well known as Vice Chancellor of Maharashtra National Law University, Mumbai. After resigning from MNLU Mumbai, he rejoined as adjunct professor at Damodaram Sanjivaiya National Law University, Visakhapatnam, and acted as registrar. Then joined as director of Keat Law School at Bhubaneswar, and then chair professor of human rights. He has numerous publications and has been an active member of different academic, executive, and financial councils of various institutions till date. Now, I request him to enlighten us with his words on historical aspects of legal education.
Thank you very much. It's my privilege. First of all, I congratulate Manik Chand Pahade Law College for celebrating its 68th Foundation Day. 68th Foundation Day starting in 1956, sharing my same birth year. Now it's a wonderful journey for Manik Chand Pahade College to reach to this particular status. I have been observing this particular institution for the last 10-15 years. It has grown exponentially and contributing so much. And before that, let me pay my respect to the principal, Professor C.M. Rao, the principal, Dr. Aparna, IQAC coordinator, and the vice principal, Mori. And dear colleagues, faculty members, and students. I was listening to Dr. Aparna. She has been telling this particular day, Foundation Day, is a day for making a self-analysis, looking into self, how did we travel? And travel of Manik Chand Pahade Law College can be the historical aspects as far as the legal education is concerned. If you can really write down the starting commencement, year-to-year development until the time that we reached here, whereas last 15 years, last 7-8 years, right from 2015 to 2024, I have been seeing your brochure. Almost 24 national and international accreditations have accredited your college very distinguishedly. I congratulate you all for that reason. And an excellent record. So 29 accreditation bodies have been accrediting you in a wonderful manner. And I was really surprising why it should not happen. Because I have seen that almost 120 legal luminaries across the country and judges from the Supreme Court, legal luminaries of the cadre of Upendra Baxi, Professor Madhav Menon, and name the who is who in legal education, almost all of them have visited your law college. That means this law college has really made a mark of its own in the spectrum of legal education. Now, coming to the topic of the day, I must tell you something. That is, legal education, because you are students of law, who have been pursuing law for a long time, who have been content with law, is not sufficient. When you are content, your knowledge is complete. When you are not content, you strive and you passionately look forward for something new and something different. I don't know how many of you are really satisfied with the history of legal education. Whether you are satisfied or not satisfied, history is a fact. Yesterday's fact matter. But what has gone right and wrong? That is our job to look into that. I'm sure the future of the law schools in India or the law school like Manik Chand Pahade Law College. It's not that the law colleges which are like national law universities. National law universities are today more or less elite schools and they've been contributing to the upper class of the society. They don't understand, they are far from the social reality. Social reality can be understood only by those particular people who come from the grassroots and have been studying in a difficult situation, understanding the people, sharing their empathy and apathy. Unless you have that particular empathy, you cannot do a good social worker. I say social worker for the reason lawyers are, first of all, they should be social workers. If you have the particular heart to help others, then only you can be a wonderful advocate, what is needed. But that is not the case in our country. The case in our country is almost all the people who join into legal education with the heart to help other people, slowly and slowly they got trapped into money and money and money. And money is the only end point and end game. Helping the people is a privilege of only very few advocates at the top level and at the low level somewhere. And they are unknown, unseen, unheard, unrecognized. Because they are not among those particular people who earn big money or they are the big names. And those particular people help, they are unseen, unheard. Let me take you to the country's legal education. Let us look why our legal education. Sometimes when I ask this question, how is the situation of legal education in the country? As far as this particular country's legal education status today is concerned, it's very, very bright. I'm seeing around 60 to 70,000 students every year they join into legal profession. 60 to 70,000 students join into legal profession every year. 60 to 70,000 students take the examinations, the CLAT, for getting a seat in law schools. Now only 20 or 30 law schools are there. 30 law schools will be needing around 3,000 students. After that, all other law students, they join into other law schools. Whatever it is, 60 to 70,000 students is the lower side. And almost we have in this particular country today 1.5 billion advocates. But still the figure is less. Probably the rough estimate of this particular country, we need advocates to the tune of around 30 lakhs. That's 3 million. We require nothing less than 3 million advocates. So we are now off the mark. The reason why you need 30 lakh advocates, because 4.7 crores cases have been pending across the courts. The problem is who have been only doing a legal education. Where is the justice education? Legal education for what? Legal education for the purpose of giving and deciding the disputes, that's all. In deciding disputes, are you sure that you are establishing justice? It is a question. We never bothered about justice education, nor the Britishers ever bothered about the justice education. It is only a dispute resolution organization. But we call our judges as justice. The lords of the court, no doubt they're the lords, because they command, we listen. But they are not justice. Let me be critical over here. Without mentioning anybody, I don't mean any particular person in general. I'm looking at the history of England and India with respect to legal education. And unless we critically think about this particular legal education history, you cannot really understand. The law of India are based on common law. I'm sure all of you know what is common law. Common law is a system that is developed out of the cases. Whenever a dispute is there, the matter is taken up by the court and court gives a decision, and that decision is based on the basis of the facts and the situation prevalent at that particular time, which is called law, or to start with the 13th and 14th century, it is the king. Yeah, sometime during this particular Henry VIII, during 1200, 1300 century, the 13th century, this particular system started after the Norman the conquests. Look, England started this particular legal practice after the Norman the conquest. They have taken up the clue from German system. That is to base their emphasis on the law. But ultimately they could not follow the German methods. They started developing their own method that is called as common law method. German method is the civil law method. So in contrast, we come down to the common law system, that is a precedents are created. Whenever a dispute is resolved in the king's court, king will be appointing judges and judges has to decide the matter, and that particular matter becomes the decision, and that is the law of the land. And in the next forthcoming cases, this particular case becomes the illustration for deciding the next or the subsequent opposed cases. So that is how the common law system started developing in England. And while deciding these particular cases, my God, if you look into this particular Henry the Eighth time, Henry the King, Henry VIII, the situation was eminent judges like Sir Thomas More was there. He was the Lord Chancellor, an acknowledged man who is a man in many particular strides. He was a man of literature. He was a man of law. He was a judge par excellence. He was an advocate. He was a Lord Chancellor. He was a parliamentarian. He was everything. But you know, when he did not agree with the king, Henry VIII, what has happened? He was beheaded. It is a fate of the judge before the king. And that is where your legal system started. The judge was beheaded, judge was punished. And he was not the only isolated judge. The judges were also not free from the draconian head, Damascus sword. The sword is hanging on their head. It is Thomas Wolsey, under Lord Chancellor, during that period of time, in the year of 1530, he has been accused of treason, and he was also given death penalty. He could die before the trial could start. I'm sorry. So this is how the thing started in England. And those particular people who started following this particular legal practice, who are they? And how did they go into legal practice? They are basically social workers. They wanted to help the people who are in difficult situations. And then they started taking up the matter, advocating the cases before the court of the king. And these particular people started training the legal education in a way by the time it started up to the formal legal education started, it was only by apprentice model. You understand what is the apprentice model? The apprentice model is you also go to the court, you do apprentice, internship you call them. You go to the court, go to an advocate, join with him, visit to the courts, you try to understand them. But 1 month apprentice will not work out. There the judges, there the advocates used to work for about 3, 4, 5, 6, 7, 8 years, maybe more, until the senior says, yes, you can go and make your own case on your own presentation. That is how the legal education started. It is no formal recognition as, and I'll tell you in Oxford, also the legal education started formally very late. They used to award the law degrees, no doubt, BCL, but the formal legal education started much late, almost 18th century. 18th century. Mind it, I will take you to little more history. The father of jurisprudence, who is he? Jeremy Bentham is called the father of jurisprudence. A philosopher and a jurist who has given the theories of utilitarianism, who has spoken about pain and pleasure theory, who has spoken about all his life he spent the time for designing how punishment should be given and what type of punishment, what type of jail system, what should be the penitentiary or pentocopy. He gave the name pentocopy is the name for the jail. How the punishment system should evolve. And it is he, you must be knowing this particular legal positivist, John Austin. John Austin is, his name is very popular. In the 18th century, he has been guided by Bentham to be the professor of jurisprudence in Oxford. And when he started taking classes in jurisprudence, he was not very much clear about how to go along with the legal education. He only started with saying that whatever pleases the king, that should be the sovereign, that should be the law. So he said, law is a command. We should with sanctions. The positivism started from there. Anything against the king, there can be a situation like Thomas Wolsey or Sir Thomas More. So judges were also scared, and they were not independent. And the decisions that are coming, definitely they have been looking to the king, whether the king will be happy if the decision is given. If that is the type of situation, and you can create narratives, which is called judgments. Legal reasoning is different for that reason than the natural reasoning. You will read Lewis, you will understand what legal reasoning is. You are trying to connect logically the symmetries and thereafter establish the theory. Logically they are correct, but naturally they may stand, they may not stand. So this is where exactly the difficulty started happening. Now, coming to these particular difficulties, I feel somewhere in the whole system of the king, law, justice, there is an element of bias. There's an element of arbitrariness. There's an element of support, almost support to the government. Sometimes we call committed judiciary, isn't it? Judiciary should be committed to whom? To the government, to the state, to the sovereign. If that is the situation, who is the biggest litigator today in the country? The biggest litigator today in the country is the state. Why I am saying this? I'm not trying to be critical over here, but I am trying to tell to you how the things have started developing. So somewhere in the genesis, you have this particular element of arbitrariness. Arbitrariness means inequality. Inequality means corruption. The last final word is corruption. So whenever there is a corruption, whenever there is arbitrariness, whenever there is a inequality, then there is a situation of it is the last nail in the coffin of justice. Justice is killed or justice is buried. But what we have seen, we have started saying that this is what justice is. That is the reason we don't call that the court of justice, but we call them, they are the court of justice, no doubt, but they are the court which delivers legal, they settle the legal disputes. Then I don't think any particular court is giving really justice. For that reason, our education is not justice education. Our education is legal education. What is our education? Legal education. So history of legal education goes from the training the advocates derived from the King's Court advocates as a practitioner apprentice. This is how these particular people, they started doing the practice. And these particular people, they have given us a volume of cases which are called precedents. I will take you to the situation of Edward Coke, the Lord Chief Justice LCJ of England, sometime during, I will tell you which period, 17, I think he is, Edward Coke is from 1552 to 1634. During this particular point of time, the 16th century, 17th century, Edward Coke was the Chief Justice. And it was his book, his textbook, which is called as Coke's Institution. Coke's Institution. And that particular Coke's Institute has been the biggest collection of all the precedents. And the advocates who want to go to the court of law to practice, they must understand what is the precedent on that. There was a time when the advocates used to remember, even in India, hundreds and hundreds of precedents. Hundreds. We don't now really need to remember. We have our idiot friend Google. He helps us. And we don't need to remember anything as such. Remembering and memory is a last thing that is required today because we have the Google friend. But earlier, the advocates, the judges, they used to meticulously remember the precedents. And Edward Coke developed the first. The next book that I developed was by William Blackstone. William Blackstone synthesized all the laws, both the civil laws as well as the common law. And Edward Coke has given this particular book called Coke's Institutes. It is in the year 1610. And he has gone into controversy because he did not agree with the judge. Again, he said king in his own person cannot adjudge any case. And he said king really needs the intellectuals, learned people who are called judges. And this was not accepted by that particular James I, at the time the king. And Coke defined what is the rule of law. And Coke, when he defined rule of law, he categorically said absence of arbitrary power on the part of the government. What was not accepted by the king at the time? The king was James I, and Coke was saying it is the rule of law that should be the ultimate power. Absence of arbitrary power on the part of the government should be struck down. And he also said no man is punishable or can be made to suffer except for a distinct breach of law. Except for, means in other words, what we are saying in Article 20 of the Constitution, ex post facto law. If there is no law, nobody can be punished. So these are some of the things in the rule of law in your article molded today. At the time, the king did not accept him. Ultimately, Lord Chief Justice has to resign. Edward Coke was resigned. Now, why I am quoting Edward Coke is Edward Coke was associated along with Francis Bacon during that particular time. Francis Bacon was the Lord Chancellor. And Francis Bacon himself, why I am trying again to tell you about Francis Bacon is he has admittedly pleaded guilty about bribery. Lord Chancellor of the country, the ultimate advocate of the country, has pleaded guilty of bribery and he has been sent to jail. The quality of the judge, mind and look to the quality of the what made Francis Bacon to be guilty? Bribery. So bribery has been there somewhere, molded in different degrees into this particular judicial dictum. Why did it happen? Because he had no value for law. If a Lord Chancellor did not have the value for the law, why he didn't have the value of law? Because he knew pretty well during the same particular time, James I, who did not agree Coke's words, arbitrariness should not be there in the government on the part of the government as one of the essential mandate of rule of law. So when the king can do wrong, why till I should bother? What is justice? I'll be giving justice something according to my understanding, and somebody above me, he may turn it over, or somebody is not pleased. So again, I have to mold the law somewhere else. So this is how the arbitrariness was creeping in. It was creeping in. So judges were never free. If you read these particular books of Lord Dennings has interestingly written few books. The Discipline of Law, What Next in the Law probably, then Landmarks of the Law, and the closing chapters of some of these particular 4 to 5 books he has written, Lord Dennings. In one of the books he explains very categorically, probably in What Next in Law he explains how these particular judges have made this particular legal interpretation, which is called legal reasoning, and how the legal reasoning is different from philosophical reasoning. But mind it, when a Francis Bacon, when I was speaking out, is not a small person, an ordinary person who has been put to jail because of bribery. He has been called as the father of modern science, for your kind of information. All your empirical research today, empiricism, including Sir Isaac Newton or Einstein, probably has to give acknowledgement to Francis Bacon for accepting this particular philosophy. There is something which can be observed in the society, and that observation should be the basis of law. So empiricism has carved in. And deductive logic has started carving in until that inductive logic was working out. So Francis Bacon is not an ordinary person. He was a great person in literature too. You ask any literature student, you must be knowing Francis Bacon. You ask any particular law student, you must have to know Francis Bacon. You ask any particular scientist of that particular era, they must be knowing whether Galileo or Newton, they must be knowing Francis Bacon. So Francis Bacon was such a person, but he was sent to jail. He was in the glass house, which is called the jail in England. Of course, he was exonerated from the punishment, but still he was not allowed to take any position any further. And very unhappily, he died a little later. But I want to say, if you are looking into this particular personal characters of a judge or an advocate or a Lord Chancellor, probably I don't know whether character can be separated from the justice and discriminatory process. Yeah, public life and personal life, I understand this particular hot and full of debate pretty well. Private morality and public morality, but still I'll tell you, morality has something to do more. And this basic moral, though you have reduced to ethics, is very, very essential. Why this ethics has been lost? Why this moral has been degraded? Because there is an element of fear. Where from the fear came? Because from the king, the ruler, the sovereign. And we are appointed by the sovereign for delivering a thing, and we are scared Tomorrow, if I don't really deliver a jet which pleases to the government, I may not get another particular opportunity to be a, I don't know, chairman of a commission, or maybe what I should say, I might not be appointed by an arbitrator, or I will not be considered for any other higher upper positions. I've been a judge of the Supreme Court, but still I've been thinking this. Mind it, this is the status. And where this particular idea has come, I'm not blaming our judges. This is there that is ingrained into the minds of the legal education or the educational process or the cultural or structuralization process of legal education that we've been studying. Now, coming down, I'll tell you the first law school in the whole of the world may be coming from America, not England. The first law school started in America in the year 1784. It is called Litchfield Law School. And after the American law school, in England, in Oxford, they started starting the formal law school. Now I'll take you to Austin, John Austin. John Austin was a ex-army guy and retired from army, came down, and he was sharing his house as a neighbor to Bantam. And Bantam and he, they somehow from time they discuss on matters. Bantam felt pleased. Probably Austin can speak on jurisprudence, and it is on his recommendation he became a teacher of jurisprudence in Oxford, and he started giving lectures. Lectures of Jurisprudence, it is a book that is published posthumously by his wife, Clara Austin. Okay? And when Austin himself was not pleased by his classes, because you're seeing that whenever you wanted to deliver a class, sometimes we also do that. If a teacher is not good, that we go out from the class the moment the teacher enters. So also, when Austin wanted to take classes, most of his classes become empty. So he has quit this particular teaching position. Again, Bantam took and made him appointed as a law commission member. But he has given the philosophy what is called law is a command. Now link this particular law is a command to Thomas More, Edward Coke, Francis Bacon, and Bantam. Why did he say law is a command? I accuse him that he is scared about, he was not bothered about the telling this particular non-arbitrary, judicious or justice. He's only speaking of law. He's not speaking of justice. And he says law is a command and is issued with sanctions. And this particular law can be arbitrary. Okay? At the time, we didn't have the particular concept called Article 14, equal to equal law and equal protection of law. So imagine the situation, law is a command. From that particular philosophy, later on, I was fortified to run the government as a, and when Edward Coke took over the situation, it was almost which year? It was almost 18th century, 1781. If I remember correctly, John Austin, yes, he was born in 1790, and during 1832, he became the professor of jurisprudence, and he died early. That is how Edward Coke was giving lectures of jurisprudence. And we know pretty well other positivists. We started glorifying this particular Austin, Hart, and all these particular British legal philosophers. Wonderful. And they spoke of justice. And we probably got along with our mind to only think this particular common law system. We never had the opportunity of thinking of any other system that is prevalent in the whole of the world, including Indian olden days. And the grand old days, ancient India, the law in India was something different. And there could have been also maybe a hybrid of civil law and common law, which India today is trying to mimic, bit of civil law, bit of common law. When you call adversarial system, when you call inquisitorial system, all these particular things that have been coming, they'll be playing. They're playing forward and forward. Now I will try to take the example of our 3 new laws that have been passed. What are the 3 new laws that is passed? That is making rounds: BNS, BNSS, and BSA. That is Bharatiya Nyaya Samhita 2023, Bharatiya Nagarik Suraksha Samhita 2023, Bharatiya Shiksha Adhiniyam 2023. Look, I am trying to tell to you people how this particular drift has been taking place by the example of this particular 3 laws. Now, in India, the legal education, almost until your law school started in the year 1856, nobody knew much about law. Anybody who doesn't get an opportunity to join anywhere, they used to join law. This was the situation almost up to near year 1980. Law schools were there. Law was not a charming profession. It is very difficult to cope up in the court.
Vani, voice cut over. Vani sir.
Maybe there is some technical glitch. I request everyone to stay tuned. Just for a while, we will have a communication with the guest.
So the guest is coming within few minutes. Wait for a moment.
Participants, kindly wait for a few minutes. There is an interesting announcement coming up next. Wait for the chief guest.
Aparna, go ahead with other program. So you want to announce something, I think. Aparna,
Yes, sir. Yes, sir.
ask
Um,
you. to go.
Yes. May I now request Dr. S.G. Shirsat sir to make very interesting and important announcement of the event that was conducted by Green Club. Shirsat sir, please.
Thank you, madam. Respected Panda sir, Honorable respected Dr. C.M. Rao sir, respected Aparna Kottapalli madam, IQAC coordinator, and respected Sri Krishna More sir, vice principal of this college. The college is trying to provide the many platforms for the student development. And one of the major initiative we have taken to have the Green Club activity, which is headed by Dr. Aparna Kottapalli madam. So, as you well aware, on the 5th June, we celebrated International Environmental Day, where the college have asked to participate in the poster competition and the slogan competition, where 38 students participated. Let me thankful to Dr. Shampadev madam, Christ Law University, Bangalore, who have tested or examined all these poster competition and the slogan competition participants and given the assessment result. So let me give the first winner of the slogan competition, and that first prize goes to Mr. Amer Sayed, and second prize goes to Miss Vaishnavi Bhale. At the same time, the poster competition was also had a very good response, in which the first prize backed by Sakshi Chondiye, and the second prize is divided in 3 participants, that is Sarmishta Wire, Aditi Boyers, and Tulika Mishra. So on behalf of MP Law College, management, principal, staff, and students, I congratulate all the students for participating and bagging these prizes. Thank you very much for giving me this opportunity to announce these results. Thank you very much. Over to you, madam.
Thank you, sir.
Someone check whether Bhavani Prasad Panda sir joined through phone.
No, shall I continue or can you start
Go
the
ahead,
meeting?
sir. So if you join, go ahead. Go ahead. I'm
Yeah.
waiting.
Yeah, I was speaking to you people about, let me continue. I'm sorry for the power interruption and my network got disconnected. I have a very important aspect to explain to you people. The whole of legal education history is of very recent origin in India. And most of this legal education in India is happening by not by the advocates or the judges, but by the law teachers. Law teachers who have been dedicating themselves to be a full-time teacher and give the best of the education to the students, they were controlled by the Bar Council of India by giving this by a particular syllabus and course curriculum. And the course curriculum and syllabus is only British oriented. and it is based on the common law system. I remember when I was a student, we were only been taught how to read the cases more rather than the legislation more. And legislation never bothered. Even today, you go to an advocate, tell him that is a wonderful law that has been passed. What is your opinion on that particular law? You will tell, why are you wasting my time? Tell me if you have a litigation, if you brought a litigation to me, I can tell me what is the money that you're going to share with me. Then I can apply my mind and think on it. If there's no particular case, there's no particular aspect, I should spend my time on that. My time is quite precious enough. In fact, senior advocate's time is very precious. He doesn't have time to read the legislation and tell to you unless it is being remunerated. And in other words, what I want to say is the legal profession in India, I'll tell you the advocates, our Indian advocates, 15 lakhs advocates, 1.5 million advocates, they're all independent characters. Nobody has paid them for their money, for their studies. And nobody has guided them for the studies. They studied on their own. They invested on their own. They learned on their own. And they've been practicing on their own. And all throughout they have been struggling. They struggled. Because they have not received any support from anybody, they are very indifferent. This is one of the reasons I find. And they're indifferent because they know that time is now precious when they are earning. Almost half of their life has gone away without earning, only depending on and struggling and struggling. Be it an advocate, be it a judge. Half of the life of an advocate or judge goes away in the court, simply waiting for the opportunity when it is going to come. And it never used to come before at least 50% of the age, up to when somebody is 40, 45 years, he gets the case. And like these days things have improved. No doubt a young graduate also gets around 10,000 bucks if he is able to do something in the court. But it was not the case earlier when the legal education started, and almost up to 1980, 1999, almost 2002 also. So things have changed after the National Law University that has come into picture. And the legal education never commanded any respect anywhere in the country. And legal education was taken by those particular people who felt, okay, I can do something over here probably. I'm unfit elsewhere. So this is the legal education. I'm trying to tell to you the position of the legal education. The people who have gone into legal education, they are all self-made people. They doesn't have a leader. They themselves all are leaders. All advocates are the great leaders. They know how to lead, but they don't know how to follow. They can never follow because they're the leaders. Now, how many advocates that you have? 15 lakhs advocates that you have. 1.5 million advocates that you have. And this is the world's largest civil society. Civil society because nobody pays them. They are not in employment of any government. They are a non-governmental organization. They are a civil society, and they are an organization which is called as Bar Council of India or Bar Council of Supreme Court or Bar Council of X and Y and Z. These advocates, they have their own commonality to fight for themselves. And then they don't have, there's no single unity among themselves with respect to a common agenda of the legal education. Legal education is thrust into Bar Council of India through the Advocates Act for whatever the good reason it is. And today, Government of India is scared about touching the legal education aspects and control the legal education as such. They have left everything to the Bar Council of India, like Medical Council of India, new education policy I'm speaking about. New education policy has allowed the advocates to control the legal education. Now the advocates who are only LLB graduates, with all due respect, they are learned advocates, they are ready to control today legal research. Legal research, I don't know whether it should be called the research the way it is happening in Scopus articles and all those things, or the empirical research or doctrinal research. So legal research is another subject which is also will be controlled by the advocates. Also higher education, LLM also will be controlled by the advocates. And LLM, it is not necessary that an advocate should study LLM to be an advocate or even to be the judge of the Supreme Court. So the paradox I'm telling you, the paradox is somebody who doesn't know me is going to control me. And they have been controlling, they have been accepting this particular control method. Wonderful. Now, what I want to say is it a power game or is it an educational agenda? If it is a power game, we are getting lost. And this power game, how it happened, how it is happening, the whole of legal education process is a big challenge to all of the people wanted to call themselves legal educationists, not justice education. And this legal education to think, need to think whether this everything in this particular system is correct. For example, let's discuss about criminal justice system. Whether the criminal justice system is really successful in this country. One of the questions that comes to you is, before looking to the system success, whether you are happy with your police system, police administration, they are the three wings. What is criminal justice administration? Judges, criminal courts, prosecution, including police, and jail as operators of punishment. Do you think that your jails are wonderfully working? Jails probably somewhere has failed to keep these particular people real criminal inside, and real criminal is moving outside, and those particular seemingly criminals, they are inside and they are only symptomatic, and they don't have advocates to fight for them. For that reason, they are languishing in the jail. If some good advocate is available for any particular inmate in the jail, probably he can also move outside, like many of the great criminals who have been moving like a babu in the society. We know in our system, a man cannot be accused of a crime until it is proved beyond and it has been said that he has committed an offense. A mere accusation is disastrous. So, a guilty convict is a very difficult proposition. How many cases were able to prove the guilty of the person? I think out of 100 cases, we have already established, let 100 criminals go free, let not single innocent person be put into jail. A wonderful concept of natural principle of justice. But that doesn't mean that we will leave the criminals free. And the criminals have all the opportunities. The whole of the system is criminal justice system, not victim justice system. Nobody bothers about the victims. And where is the justice? Who needs the justice? The victim needs the justice. Criminal doesn't need justice. And who is put criminal in that particular situation? He himself put himself in that particular situation. Now, whatever it is, the criminal justice system is probably somewhere in critical situation. We need to relook what should be the criminal justice system. What is this particular public law called criminal law? How it should be handled? In my opinion, jails are not functioning to the requirement should function. Police is not doing the job as it should do. Some is spent in what I should say, government jobs or the state bandobast. And prosecutors, they have no interest in the case. They've been paid by the state to make a particular decision this way or that way. They may argue very seriously, they may not argue seriously, but maybe it will be appearing that a prosecution is happening, and that the defense counsel is always a strong and ultimately the accused person gets the benefit of the law, benefit of the doubt. So ultimately, the whole criminal justice system to me is a very, 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 very slippery area. And all this slippery is happening because the origin of the criminal law, the origin of law, arbitrariness, capricious, maliciousness. I'm making an accusation. Though we have Maneka Gandhi versus Union of India, where it has been said, procedure established by law. You are trying to only mold of this particular situation by a window dressing, or I should say, a superficial arrangement for saying that, yes, everything is in place. Everything is not in place, my dear sir. Everything is in shabby. Everything is in very difficult situation. Suppose you are the person who have been in the crux of legal litigation or criminal litigation, then you will realize how the whole situation is murky. How the whole situation. Today we are finding a A person who has been there and languishing in jail for 27 years, Supreme Court says, okay, he should be acquitted. Who is going to give back his 27 years or 28 years? What justice you can do for that particular person? No answer. No answer. If this particular person who has been languishing for 27 years, he can be acquitted. A person who has been put into death penalty, a person who has been responsible for the assassination of the prime minister of the country can go out of this particular Indian court walking out because the state makes a alibi and plea that that particular person should be excused. What is justice, my dear friends? Somebody should argue for you, no, isn't it? I wish Harish Salve or Venugopal or Gopal Subramaniu or and any eminent advocate, if they argue properly, we have a better chance to not to go into jail at all. If no advocate is available, if a person who has been a first timer and who knows little about the court or the little about the judge, I don't know how much chances he has to be in the public. Look into this particular system, my dear friend. And what is the remedy? What is the remedy? Remedy lies probably thinking very differently. We are not thinking differently. We are stereotyping. We are copying. We are simply following like goats whatever the system that has been thrust on us. A system is being thrust on us, and we have been following that particular system. We don't want to raise a voice against the system. And for raising a voice doesn't mean that you're going to make you're going to make a particular breakaway situation. You're going to raise your voice scholarly. You need to write research articles. I have been telling this particular system is not working, and there are a lot of dissatisfaction. There must be something where it can be better. Look to the whole of the world where the system runs wonderful. Look to your own mind, how you can get justice and how can you ensure justice to somebody. And that justice will be looking. We're 140 crore people, my dear friends. We need to think of this particular system. We have to be the leader of the nation. Now coming to this particular three laws, BNS, BNSS, BNSA. What is this particular Bharatiya Nyaya Samhita? Indian Penal Code, some window dressing, remove certain sections, add some sections, and give different name. Is it a new law? Well, I'm not blaming the government in power who made these particular changes. I'm blaming the people of this particular country who never bothered to think what should be the. India lost a wonderful opportunity when the Honorable Home Minister Amit Shah I want to change the criminal law of the country. He has written letters to every law college, every law student, every advocate, every judge. Please suggest me what should be the new law of this particular country, criminal law of the country. Nobody replied, my dear friends. None of we participated. We're all equally responsible. We never bothered to look. And we have now I have been making a sound. Yes, everything is not in right place. Criminal law system is not working. But did I write an article? Did I write my recommendations to the Home Minister? And how many of us have done this particular lobbying to say this is not the criminal law that we are looking for? We want justice system. We want victim justice system. We want something different in the whole of the world. We want to ensure justice to the people. In your preamble, my dear friends, read the Constitution several times. You'll find the word not law. It's a justice. We have to ensure the justice. What to be justice? Socio, economic, and political. These are the three forms of justice you must ensure to the people, but not by the legal system, my dear friends. You cannot do that. It's only deciding the disputes. It's a resolution of disputes. You are not in the position of resolution the dispute. It's an alternative dispute mode also can happen. Dispute resolution. Bring two parties, share them their bounty. Both the parties are satisfied. You are also satisfied, and let 140 crore people they go anywhere. How does it matter? Because those particular people are litigating, they are satisfied. Litigating people are not the ultimate, they are the tip of the iceberg. Tip of the iceberg. If the government in power and the criminal in the focus are satisfied, that doesn't mean 140 crore people of this particular country are satisfied. We need justice. 140 crore population of this country, they need justice. They don't want whether they compromise between the buffers gun and the government and ultimately say, yes, we have got justice, we have done this justice. No, we don't want that. We want justice, and we don't tell that you're deciding the dispute and settling the disputes. And it's not simply that you're trying to make a narration, a narrative in the time of in the language of legal interpretation or legal reasoning and legal policy, not justice policy. A precedent is called as a legal policy, a legal principle based on legal policy. And this particular precedent we don't want. We want what is called a justice. My dear friends, you people have a responsibility today. We need to think very categorically, what are the other wonderful systems where justice is given? What other system can happen? And do you know, when Indian Penal Code was drafted in the year 1834 by Macaulay and his team, the whole law was drafted within 4 years. By 38 it was done. No, this is not the case. Indian Penal Code drafting process started in the year 1834, continued almost up to 1860. Due to different particular political situations in the country, 1834 to 1860, if you understand the political situation of the country, it has traversed in different manner. Drafting of a law, it took criminal law, it took more than 30 years. 30 years. Today, the Indian Penal Code, which has been drafted in the time of Bharatiya Nyaya Samhita, we have lost that opportunity. We couldn't do it. We have simply copied it and said that we have made everything. I think this particular laws would have taken at least a period of 10 years, minimum 10 years to draft and give a wonderful law. Law different from the whole of the country, law which ensures justice to the people. It didn't happen that. It didn't happen. It is only a quick ointment. But I'm telling you, it's only simply a chemotherapy to the cancer, for which reason the patient is going to die definitely, but nothing can happen. Nothing can happen. You cannot save the patient. You cannot save justice. You are killing the justice, my dear friends. You are giving chemotherapy to the person called justice, and justice is going to definitely die. If you wanted to really give a treatment, you need to think over a period of time, wonderful diseases to happen. Well, I have ideas, but this is not the forum where my ideas are important over here. But I'm only trying to explain to you people, you need to think differently in legal education. Otherwise, the legal education that we have inherited is by itself polluted. The common law system is itself inherently arbitrary. Inherently, it is capricious. Inherently, it is malicious. We are trying to give a dress up. It's not malicious. It's not that you have added the new words, rule of law. You have used the new words like due process of law. You wanted to ensure some wonderful goody word somewhere, but without seriously meaning it. If you would have seriously meant what the law is, what the constitution, if you seriously practice constitution, things would have been different, my dear friends. 70 years upon place, constitution has guaranteed certain things in preamble. Why it is not happening? Because we are not serious about it. None of the, I don't know how much of the founding fathers have been very serious about this particular law, this particular constitution. If we would have been very much committed, how many of us really understood the constitution? This is my rights, fundamental right. This is my right, directive principle set policy. This is my state, union and state. This is the division. This is the governor. This is the prime minister. This is the president. My God, I'll tell you, we have been not educated on that line. That is where the legal education is going on wrong. Legal education has to happen for the purpose of justice. But we call it jurisprudence, but we don't call it justice. My dear friends, it's time to think your social justice, your economic justice, your political justice. So keeping these particular things in mind, I hope all of you are going to definitely re-examine the situation. That even I remember if you really can't be helpful to the society, for what purpose we are living? What purpose our life is? We must be able to help the society as a liars, help the people, to help the government, to lead the government, and to lead the government for making this particular country wonderful. And I'll tell you, we cannot be Francis Bacon, we cannot be William Blackstone, we cannot be Edward Cox. And that was the time, and that was how England has gone through. It is socio-economic political conditions were different, but now the socio-economic political conditions of this country are different. Today we have certain particular, what I should say, opportunity to think. Yesterday we didn't have this opportunity. Yesterday we were only closed minds, but today we are now in an open air. And our Honorable Home Minister has given wonderful opportunity to think and make the law, but unfortunately, I don't blame him. I blame those particular people who have been the brain behind these particular three laws, to just copy the same law and convince the Home Minister, this is the new law, this is the new thing that we have done. And now government is spending hundreds of crores on this particular to educate the people and train them how to follow this law. Is it necessary? I don't know. Maybe it is. I'm probably far behind now to understand the idea of the government to accelerate the training schemes on this particular three law. This tinkering, these things could have been happened by an amendment, simple amendment to criminal law. Well, we have not changed anything from the West. We are still the same Anglo-Saxon law. If you really wanted Bharatiyata, think Indian, think Bharat, think about Dharma Shastras, think what is the best for the whole of the world, and let's do it. Let's do it. Thank you very much for giving this wonderful opportunity. And any questions I can take up now? Any questions?
Yes, sir. I have a small question. About the legal education, are there any special areas on which we can focus upon while formulating the syllabus, while formulating the course content that stands in need of our ADR, etc. is included? But apart from that, as you were talking about Bharatiya, thinking of Bharatiya, so even the jurisprudence which we learn, it is completely rather nothing is there in the course content about what kind of jurisprudence the Indians or the Indian legal system had in their, in the mind. So can we think of incorporating any special areas in the course content so that the students will be enlightened with, the Indian cultural ethos and the morals, Indian morals?
Yeah, I could get your point that you wanted to have certain things which is new should be put into this particular system so that we can do a good research toward the Bharatiyata. That is the question that you're asking me, probably. Am I correct?
Yes, sir. Yes, sir. The same question.
And if this is the question, first of all, I'll tell you, we have been so much conditioned in our minds. This particular legal education that we have been speaking today is in our DNA. Every particular moment we cannot make ourselves away from this particular law. That is what we're studying today. First of all, learn how to disconnect yourself. Unless you critique this particular law that is existing in its totalness, just lock, stock and barrel, this legal education is obsolete, not meant for justice. You think in this particular plane, and holistically, you need, once this particular thing is out of your mind, then you can think of Bharatiyata. Otherwise, Bharatiyata is not going to come so easily. It's not an ordinary concept. Bharatiyata concept comes from Shrutis, Smritis, and several things followed. And those things we left. Our values, our cultures, everything we left. And how to gain them back. And where you're going to pin the hole, put the pin ultimately. So this is the question. Now, if you want to be the leader in this particular area, lead through the position of law, then you need to first of all, disown what you are having, and that is a big liability. The legal education today is a big liability. It only superficially addresses the problem, and it is people are happy with the mediocrity, and they will not allow you to change because mediocrity pays wonderful things. And if you really want it, it can be done, and the research is necessary. And for the purpose of research, probably the first thing is my teacher used to tell me, Professor Menon, Professor Panda, you need to probably unlearn yourself. And the unlearning process is very critical thing because that is structurized. I'm telling this people legal education in our country is today has gone to our DNA. Our blood speaks about legal education, and we can't speak anything else. Once you disconnect from this legal education, then you can think how I can do legal education. How this particular justice can be done today, whether it should be called justice education, whether there is a Bharatiyata, and now the dharma, the word dharma that we have been using, and people say dharma has been used in different manners for different purposes and different. It is a variety of meaning. It is a range of things, and for that particular reason, you need to think dharma for the purpose of justice delivery. Justice delivery. It's a question of justice delivery. It's not law is not going to address governance is different thing. Law for the purpose of governing is different. Law for the purpose of solving the criminal law problems is different. And now we need to think differently. I'll tell you, I have also very limited entry into that because my DNA is no different from your DNA with respect to legal education is concerned. I'm learning to unlearn the whole process. Thereby, I'm critiquing. And first of all, let us try to critique like leftists. First of all, we need to understand this is not our law. First of all, we need to understand this is something counterproductive. This is something oppressive. This is something very different. It has to be disowned. If it has to be disowned, what should be owned? Automatically, you'll be getting the answer. And gradually, you can start a course on this thing. What is justice education? And probably you need to start a course. In the justice education course, probably your maximum focus will be there to critique the existing system. Critique the existing system. Critique for the purpose of critique, for the purpose of constructive building of the nation. So this is what I should say. I can't have a clear-cut the answer at the moment, but I know pretty well this is not my system. I know pretty well what has been given to me on my bowl is not my food. It is somebody's food. And that has been thrust on me and I have to eat it. Either I have to eat it or I have to stay hungry. I would prefer to stay hungry rather than eat somebody's food. This is it, my dear friends.
Yes, thank you, sir. Thank you so much. We got it. Thank you so much. Over to you, Sharvari madam.
Any other question? Any other question? I can take one more question.
Hello, sir.
Yes.
Sir,
Yes.
in continental countries, specifically in Russia or in China, the socialist model of justice followed judiciary delivery. Can we adopt those elements in our Bharatiya Tattva?
Yeah, you are asking me questions. I'm not much aware of the Russian model or the Chinese model, but still I'll tell you, you need to think on that and whether the Indian situation is ripe enough for that Oriental model, or India has its own separate model. Indian people are already, I'll tell you, by our DNA, I'll tell you, we need to understand 400 years of British ruling. And before that, the Muslims have ruled us. And India is for 1100 years a slavery country. And in this particular situation, again, you are trying to take towards Russia and China. Russia itself is a failed nation. When it started Lenin and Stalin, today they are nowhere there in the picture. Putin is there, and he is driving in different manner. And what is Xi is doing is no more Mao. It is something different. So I don't think those particular systems, maybe we need to think on our own independently. We have the philosophers, wonderful philosophers like Hobbes, Locke, Rousseau, and all these particular people. And also we have our own theoreticians, like if you go to our Shrutis and Smrutis, we have certain ideas. We have our own Chanakya. We have certain systems over there. Maybe we need to pull up ourselves and look into the system. Let's not copy anybody anything. You think for a moment you are the leaders. The nation is in your hands. Like the thing I'll tell you, Thomas Murray started. He started writing an Utopia. Thomas Murray. And when he started writing Utopia, he was definitely looking into Plato's Utopia. And Thomas Murray again has created another Utopia. And in this particular thing, he has created an imaginary island. And it's different from England. And the people, he has defined the type of people also over there. And for that reason, what type of ruling should be given. Maybe some of these particular books, if you read, you'll get interest how to think originally. And if suppose it is your nation and you have a responsibility for about 3,000 or 5,000 people, how do you give them justice? How do you think that the people are going to live happily? It is 140 crore population today. And start with a basic minimum. Think, how do I govern this thing? How do I lead the system? How do the things can happen? How do everybody is going to live happily? It's only not a mere dream. And this is how Plato thought. This is how Thomas More thought. This is how the political leaders do think. Almost all political leaders, they go over there thinking lot many good things for the nation, but ultimately they become victims of the system because that is what I should say, it's so corrupt. It binds them, it ties them. It really puts them in a difficult situation. They cannot acquit out of that thing. Ultimately, they become the victims of the system. Otherwise, why Thomas Murray has to be beheaded because he said something to the president or the King Henry, Henry VIII. Imagine the situation. And now, how are you going to do this particular situation, and how you are going to motivate the listener? And did we lose the bus? Did we lose the opportunity? I think Amit Shah had a wonderful opportunity. He has given us a wonderful opportunity. This particular BJP government, and this Amit Shah is the only character. Probably he had the power of pushing the nation to a particular direction. He had that particular force. He had that particular will, and that particular will and force. We could not give him the idea. We could not give him the idea. Probably he would have been very successful. And if you could have thought over, now the whole point that I am trying to drive is you need to think. You are a thinker. You need to think, and you need to generate ideas. If you are able to generate ideas, maybe Russian model, maybe America, maybe when the Chinese model. I don't know whether they'll work over this country because we have been for a long time languishing as a slaves, if not slaves, but worse than slaves, and we have been listening, or by that particular system, our mind has become corrupt, and we have been corrupt for the region. Our socio-economic conditions are so poor. Food was such an important thing. Half of our country people are not getting proper food. We have faced 2 famines in this particular nation, and this nation still should come out of this particular situation. I'll tell you, it's not everything failure, but the failure lies with the thinking. We are not rich in thinking. We need to think originally. We need to think what is wonderful for our nation and what type of people we are. We are not British people. We are not American people. We are not Europeans. We are not Africans. We are Indians. We are Bharat. And in Bharat, how we should think. Macaulay came to this particular country with 1-point agenda. He will make all Indians to read English and forget their own law and their own language. To forget their own law, they have to forget their own language. So he has created English law in such a manner and the education system in such a manner that we started studying English and we don't interact in Hindi or we don't interact in our own local vernacular to convey the idea that I am trying to convey to you. It is the credit of Lord Macaulay. Very intelligently, he has created a situation by which there is a cultural push. a cultural change. What is stimulus? Can you imagine? 1834, a man comes to this particular country. He thinks that India has to be like this. After 100 years or 200 years, it has become that way. That is the power of thinking. That is the power of force. That is the power of sovereign. Probably we have that power now. It is we the people. This is our constitution. This is our country. This is our Bharat. India is called Bharat. Bharat is India. This India and this Bharat can do this thing. And now we need to think. At least guarantee those. You try to see that how our preamble can come true. I don't go on to get into the whole of the constitution, which is the replica of 1935 Government of India Act. Almost everywhere we have copied British. Now we need to think something independent, own. But that is not happening. You think own, think differently. Don't accept anybody. Think on your own. Let the whole world call me mad, no problem. But let me think on my own. One step that I am able to walk independently, that is a giant step for me. Rather than by clutches of many people, I walk miles. That is not mine. I am not walked. I need to walk one step. One step for the purpose of country. One thinking for the nation. That is it, my dear friend. Thank you.
Thank you. Hello, sir. Thank you, sir.
Hello.
Sir, I have second question too. You said we should follow the Smrutis, Puranas, and all those texts, but we don't know the exact sources or resources available them. Some are mere a translation or some are loosely translated.
Right. You wanted the source
Real
material.
sense.
It is your. I'll tell you, if I get an idea, I will try to reach to the source. If I'm really thirsty, I know how to reach to the river. If the thirst is there, I can reach to the source. That particular drive, that particular passion, you need to reach to the origin. Otherwise, discard it. You cannot. Unless there is a force in your saying, you cannot do it. Shrutis and Smrutis are available and you can think of them and you see when Chanakya started all those things, I'll tell you, first person in the whole of the country, he started uniting the whole of India. The Hindustan that you're calling today, the Bharat that you're calling today, it is in a way his gift. Before Bharat, the great Bharat in the mythology, if you say it's a mythology today, the son of Shakuntala. But today it is Chanakya, with the help of Chandragupta. He has foreseen, he has created Chandragupta, made him king. He never remained a prime minister. He created brought the same prime minister, and thereafter started. Because I'll tell you, my dear friend, if you wanted to really help something or do something, it is all about sacrifice. Life is full of sacrifices. And only if you know how to sacrifice, then only you can reach to the end. You can definitely reach to the goal provided you know how to sacrifice yourself. You have to rush, you have to walk, you have to work hard. Chanakya thinks for several years ahead and meticulously works out the plan. That is sacrifice. He has not done anything, he has not gained anything. And for the first time, they have fought a war against the foreign power, Alexander the Great. And then they entered into a treaty. I'll tell you, this is something. There is international law. There is a question of statecraft, diplomacy, and the law of the lands. All these things, this particular thing recorded and used in this particular country and continent. Directly or indirectly, you are using them, but you don't recognize them. You don't tell them. So, friends, we have all the things. Maybe we need to work out how we can definitely do these things. Otherwise, make a treaty. Make a treaty. I mean to say, make original thinking. Write an original. Make a critic. Slowly, ideas will come to you. You will have your own group, and ideas will be motivated. And until and unless we start somewhere, we'll never get motivation. But we should not get rather frustrated and run away from that. Once you think something is working out, definitely it's going to happen. Somebody said very interestingly, if you start with certainty, you will end up in doubts. But if you start with doubts, you're going to definitely end in certainty. So it's up to you whether you want to start with certainty and end in doubts, or if you want to start in doubt and end in certainty. And but whatever it is, knowledge is the persuasion, and knowledge is the power. And for that reason, we need to acquire the right knowledge and put the people in the right direction. People, statecraft, policy, politics, government is very interesting area. And it's not simply studying law. Almost all these particular lawgivers or the philosophers, they are not only simple liars or advocates. They are a complete human being. At the same time, they are the people of literature. That means they are emotional people. At the same time, they are political people. It means they are people who are ready to sacrifice. Any political people means he knows how to sacrifice. Anybody who is a lawyer means he is ready to do social work, help others. So they are statesmen, they are parliamentarians, they are the judges, they are the chancellors. So in one go, there are several things. And behind them, there are an army of people who used to debate, discuss, say the things. So in our minimal manner, maybe a little support I can give to the huge problem of the country. We must wait for the opportunities. Like this particular BNS, Bharatiya Nyaya Samhita, when Amit Shah has called for this particular thing, whole of the nation, 140 crore people, they slept on it. The opportunity is lost. So once you're working very seriously, the opportunity will knock your door. At that time, you must wake up and be active. And we have not worked, we have not been active, and we allowed अमित शाह कुछ कर रहे हैं करने दो. अब आ गया BNS, ये जो भारतीय न्याय संहिता and BNS, that is Suraksha Samhita, Nagarik Suraksha Samhita, and Sakshi Adhinyam. All these particular things they have come today. Old wine in new bottle, new name. Little bit, 2 or 3 new more offenses over here and there. Sections changed. And still we are the same Macaulay. And that Macaulay, whether you call him XYZ, he is not Bharatiya. He is not Bharatiya. In
Hello,
Bharatiya
sir.
Nyaya Samhita, where you
Hello.
will find Macaulay, he is not Indian. Okay.
Hello.
Hello.
Good morning, sir.
Yes. Good
I
morning.
am Dr. Narayana, principal of Shahaji Law College. Very recently, I have retired from the services.
Oh, wonderful. How are you, sir?
Fine, fine, sir. Have you recollected, sir? Once
Yeah,
you
yeah. I
came to...
met you, I met you in your place, Kolhapur.
Yes, yes. Okay. Thank you very much, sir. Professor Rao, sir, invited for this particular topic.
Thank you.
which was
Thank you very much.
selected. Sir, 1 minute I can share, sir. Off minute.
Yeah, please.
Yes,
Please,
yes.
please.
A topic which they were selected historical aspects of legal education on the eve of 68th foundation day of that particular college. Starting from the beginning, I was here in this link. So many things you have started, sir. National law schools only for the rich people and upper caste people like that. That is one statement I heard. Then we need 30 lakhs of advocates, 3 million advocates we need according to the situation. Then legal education and justice education, 2 important words also I came to know. What is the common law in India? What is formal legal education? And the father of jurisprudence, Jeremy Bentham's theory, hedonistic calculus, pleasure and pain principle. Then John Austin's theory, law is command of sovereign. Like that, there are many important things which I came and recollected once again after your beautiful lecture. Then arbitrariness,
Thank you.
king, law, justice, bias, arbitrariness, then committed judiciary, then king can do any wrong. Lord Denning's ideas, Fuller, morality, everything, sir, all important aspects which you have highlighted in this particular occasion. I am very much impressed about your particular lecture, sir. Thank you very much. But only,
Thank you very much, Mr. Narayana.
sir, thank you very much, sir. Only small question
Yeah.
in this regard. Justice education and legal education, there are two words. But what
Yeah.
is meant by excellence in legal education? Many people at the time of talking, excellence, 50 years of excellence of legal education, the excellence in legal education, they're talking. That excellence is there only in national law schools or some other law schools other than national law schools. Please clarify, sir.
You see, I can glorify myself. I want that you should honor me and respect me in a particular manner. I say I'm so and so. It's
Sir.
my choice how I use my words. That doesn't mean that whatever I mean is you should accept me. And choice is definitely for you to understand what this excellence word is. Excellence, I cannot claim myself. The people should recognize that too. People should say, somebody is a wonderful person, somebody is a nice person. If I say that I am the best man, I am the best teacher, that's not the way. That's terribly bad. And what is required is you deliver your best, whatever you can do. Let the people take a decision. Let the people say what it is and how wonderful it is. And of course, nobody works for bad. Everybody works for the best. Everybody wants the best. Who wants the bad? So, school of excellence and all those things are a nomenclature for the particular order of life. Days nowadays, everybody uses these particular words, and it's okay. Why tell you should bother about this particular nomenclature? They're fancy.
Thank you very much,
They're
sir. Thank
fancy.
you. Even thanks
Thank
to
you.
Rao sir also. Rao sir arranged this particular, college, MP Law College.
Right. You're doing quite good.
Sir.
Okay.
Fine, sir. Thank you very much, sir. Please welcome to Kolhapur
Thank you.
once again.
Namaskar. Thank you.
Namaste, sir. Thank you, sir. Thank you very much, sir.
Hello, sir. I'm Shubham Bhausai Bade,
Yes.
LLB second year. I have a question that we live in India, that is Bharat, a democratic country. Then why is there a Sengol in parliament, that is Raja Ka Dand? So there is no democracy or what? Explain your views on that.
I couldn't follow your question, my dear friend. Can you tell me again?
So only king holds the Rajdand. So we are living in a democratic country. Why there is Sengol, that is Rajdand in a parliament of ours?
You see, when you are using the word Rajdan, that doesn't mean only king. Raj means a governance. It's a government. Followed? Rajdan doesn't mean, I'll tell you, any particular punishment is a public. It should be public. It cannot be private. Anything is public is called Raj. Raj Dharma. Raj Dand. So this is how the word is. It's not that king is giving the punishment. Raj doesn't over here mean probably king. This is what I understand. I may be correct, I don't know. But I feel Raj over here means in our country, in a democracy, Raj means the governance. And the people in the helm of the affairs are the government, who are the sitting government, sovereign, are functioning on behalf of the government. Sovereign are his agents, are all Raj. So anybody in the member, for example, in Maharashtra, you'll be saying Prashashan, you'll be calling vehicles, ये प्रशासन का गाड़ी है, ये प्रशासन का काम है, ये Raj. This is how the things is. Prashasana over means Raj. Okay.
Okay, sir.
Okay.
Thank you. Thank you all students and Narayana sir for your questions. Those questions help us also. I thank you, sir, for giving your insight and encouragement. Have truly reaffirmed our commitment to excellence, and particularly the idea of considering ourselves as king will surely head us in the right direction for being a true Bharatiya. Thank you very much, sir. Now, I
Thank you.
request I request our respected principal sir, Dr. C.M. Rao sir, for presidential address.
Respected Honorable Dr. Bhavani Prasad Pandaji, Vice Principal Mr. More, ICAC Coordinator Aparna Kottapalle, and my dear colleagues and student friends. It is a great opportunity to be with this institution for last 14 years. I am also a part of this institution for the last 14 years. My journey is only 14 years in this institution. Through this institution, I learned several things. The betterment of the society. We believe, and I also believe that the saying of Vivekananda. So I respect my mother for giving me birth. I respect my father who is responsible for my birth. I respect my teacher who nurtured me whatever today I am. And last one, is something. The MLG Society has done a marvelous job in 1955, thinking of establishing this law college. Who are getting pains to go from Aurangabad to Mumbai, Aurangabad to Nagpur, Aurangabad to Pune, Aurangabad to Hyderabad. So earlier it is only house education but not have-nots education prior to independence. And this management has made this is have-nots education by establishing an educational institution for this serving the society. And even 68 years journey, an ascent towards excellence. We are not saying we are excellent. We are going in ascent for a journey for excellence. We don't know whether we achieved that or not. We means the management or the staff. We are in marching toward that excellence in which several people are coming and going. Several stakeholders are coming and going. Up to me, there are 10 principals worked here. And there are several teachers contributed here. There are several management members sacrificed their service here without getting a penny. And there are several teachers worked for a small amount, bigger amount. And this institution reached these 29 achievements what professor has made. So 2015 to till today. So somebody is going to say that these people are paying, that's why they are getting. We never ever bought anything. We only consider our request. Don't expect any money from us. Every penny that is to be spent by the management, they think twice, thrice. How many times they will think. You don't imagine, 14 years I have an experience with this particular institution. Every faculty member, every employee of this particular thing, treat this institution as a mother. Because of this mother only we are. So as a student also, you have to learn 3 alma maters. The mother, the institution, and your batches. Your classmates. All these people are to be remembered forever. If you are not doing that particular thing while you are a student of this particular institution, there are students, Supreme Court judge, High Court judges, lower court judges, political leaders, corporators, and there are agriculture people, there are business people. So that means this institution nurtured the people from all walks of life. That means we serve the society with the wisdom of the legal education. Whether those people are doing justice or not, we are not aware. Whether they are having the humanity while delivering their duties or not, we are not aware. But we are making them to learn some values while they are a student of this college, and it is they who have to take this baton, take these values to their particular walk of life. And on behalf of the management, all the stakeholders, it is not only you, there are generations, first generation, second generation, third generation, and now fourth generation are also coming to this institution to study law in this institution. It is not because of management, it is not because of the staff, either full-time or faculty, it is because of the student who reposed confidence on this institution. Because of that, this particular institution reached that stage. It is not the particular people who sowed the seeds at that time that this will go on forever. Now, I may come and I may go on, but there are some people who take this particular thing towards the excellence of legal education in this region. We are not backward. This region may be backward, but the students who are studying is not backward in the institution. They are striving hard, and whatever the platforms we are providing, take the opportunity. So whenever we are saying something for your betterment, it is not scolding you. It is for your nurturing. It is making you to be a person to be remembered in the society for something in your life. So please, everybody is born for a purpose, as pointed by Professor. Everybody is born for a purpose. You have to make this particular thing. Think of what for you are born, why you are doing something. So there are some students who are going to ask wonderful questions. There are some students simply listen. The listening is also an art. Asking question is also an art. But at the same time, you must be in a position to pose questions for the benefit of others. You are also doing service to others. Whatever the question you asked may be useful to you only. Don't think like that. It may be answerable to someone who has some doubt in his mind. So at this juncture, on the 68th Foundation Day, on behalf of the management staff, I congratulate all the people who joined in this particular online celebration. And I am happy to announce that tentatively our offline classes is going to start from 21 of August, 21st of August. Please get ready for that. 21st of August, the offline class tentatively. So thank you for all for your patience hearing. Thank you, one and all.
Thank you, sir. It is really an honor to be the part of this firm foundation, MLMG Society, MP Law College. As we conclude today's celebration of our College Foundation Day, it is my privilege to extend our heartfelt thanks to everyone who made this event a grand success. Firstly, I extend our deepest gratitude to our esteemed chief guest for gracing us with your presence. A special thanks to distinguished faculty members, the President, Vice President, Secretary, Joint Secretary, and all ML and GE Society staff, technical assistants, whose tireless efforts and dedication make this institution what it is today. To our student body, your enthusiasm and participation have been vital in making this celebration memorable. Thank you one and all for directly and indirectly making this program a success.
Can I leave? Can I leave now?
Yes,
Aparna?
thank you, sir. Thank you for your guidance.
Thank you.
With the permission of chair, now we declare that the event is over, the program is over.
Thank you, sir.
Thank you.